SJR3, the convention.
Senate Joint Resolution 3 by Representative McCollum, applying to the United States Congress to call up a convention proposing amendments pursuant to Article 5 of the United States Constitution.
Thank you, members. It's just a cleanup bill.
Convention states all through that.
Thank you, Mr. Speaker. Members, today we're very fortunate. We are fortunate that we have the opportunity to vote for a resolution that can provide a solution as big as the problem. One of those measured problems that we have today is the national debt. $22 trillion. Additionally, we have another $122 trillion in unfunded liabilities. These unfunded liabilities used for Medicare, Social Security, Medicaid. It's important to understand the unfunded liability part because this debt is being raised for just public consumption, which means that the current advantage is only to the current generation, where it becomes a little more personal for me. As your youngest colleague, I beg you to do something about this with me. But not just something about it, the exact remedy that the Founding Fathers envisioned for times like ours. And it's not just the debt, as you guys know, that's the issue. It's the general overreach of the federal government in our everyday lives. It's the regulatory crisis, federal tax on state sovereignty. I would say that federal government has essentially turned our state legislature into regional agencies, rather than respecting us for the truly independent states that we are. The biggest issue for me, it's the federal takeover of the decision-making process. Who decides what law shall be is even more important than what is decided. Washington, D.C. currently has control over roughly 65% of our budget. So my question is, are we going to let D.C. continue to decide if they know what's best for Arkansans, or do we want Arkansans to be able to decide for themselves? That's what I believe. It's what the majority of our Senate colleagues believe. It's what these petitioners believe. It's what a high percentage of Arkansans believe. And I hope you guys can surely believe the same thing today. So this resolution calls for an amendment convention for three things in particular: imposing fiscal constraints on the federal government, limiting the power and jurisdiction of the federal government, and limiting terms for its office, for the office of its officials. By the way, since I started talking, probably 2 minutes ago, federal debt's gone up $1 million a minute. I have to tell you, I started somewhat as a skeptic on this particular issue, and through history, studying,
The guys in Washington, D.C.
logic, frankly, and a little bit of precedent, I've come to the following conclusions that I want to share with you all, because I know that generally most of us agree there is an issue, but a lot of the conversation is about, is this the right remedy? As I mentioned, the Article 5 procedure, the application and prevention procedure, is the exact remedy that the Founding Fathers envisioned for times like ours. They set up these mechanisms so that the state legislature could respond, you guys, the people, if the federal government became abusive or dysfunctional. So the question you have to ask yourself is, do you feel like that is the case? Is that happening? This is the tool that the founders designed for this very circumstance. Amendments have historically been very powerful reform tools. As a matter of fact, they seem to be respected more by the courts and other federal agencies more than the actual Constitution. Amending the Constitution will help our country. I've heard many individuals object to that, saying that the Constitution isn't the problem, it's actually the federal officials. And I believe Arkansas, we send pretty excellent delegates to D.C. So really, I would tell you that most of the problems our country is facing as a result of constitutional interpretations that capitalize on ambiguities. General welfare clause being interpreted as unlimited powers comes to mind. We can restore this federal government to its proper limited place only by clarifying the original meaning of those phrases through constitutional amendments. A big, important point I want you guys to kind of reflect on is this process is a constitutional right itself. It's a right guaranteed by the Constitution, like the right to vote, like the right to publish whatever you want. Some of my conservative colleagues here talk about the rights of the states. This mechanism was set up for the people to circumvent Congress to make reforms in the Constitution they thought were important. So you as state legislatures in this process get to act as actual direct representation of the people, hence it being a joint resolution. This is a right given to us by our founders, arguably the most important check to our entire Constitution. Another, Convention of States has plenty of checks and balances. I know folks are worried about risk associated with such a process. I would make the argument that our founders were masters of checks and balances and that they put many safeguards in place to ensure that a convention would never run away. 38 states must ratify any proposal coming out of said convention before any changes would be made to the Constitution. There are far more checks on a runaway convention than on our current runaway Congress. I would say runaway courts, runaway bureaucrats. Now the opposition, I'm sure you hear, will say things like, now is not the time in today's political environment with unlimited political spending, with fear of abolishing the electoral college, and they'll say things like, shouldn't we be afraid special interest groups will rewrite our entire Constitution? No. How do we know that's the rule? There are over 400 applications out there that have been submitted to Congress for an Article 5 convention in the history of our country. As Representative Del Rosa has pointed out in the past, in Arkansas, there's several. But the reason we have never had a convention is because Congress refuses to certify that they are on the same subject matter. There has never been 34 applications seeking a convention for the same purpose. Courts have